Sexual harassment has potential penalties that could take place. When it comes down to unresolved situations, everybody needs to be comfortable, and if they're not, then it's not resolved yet. So try to find a pathway. One solution, I've seen people try to implement it before, somebody's harassing somebody in this situation, the solution is take the person that's being harassed and move them into the far corner of the warehouse. That's not a solution. The person that is receiving the sexual harassment shouldn't be the one penalized. The person that's doing it should be the one penalized. I've seen it, and sometimes it's a matter of a power thing as to, well, I'm in charge. That person, they're just reporting me because of whatever. So make certain that you're really punishing the wrongdoer, not the one that's receiving it and doesn't want it anymore and has come to you or come to the enforcer of employment law within your organization to say, I need relief from this type of behavior. The EEOC's policy guidance on harassment, inherent plausibility, the demeanor of the people that are out there, motive to falsify, corroboration, past record, other employees should be involved only on a need-to-know basis. Unless you've gone through one of these, frankly, I have to tell you, the investigators I've had to deal with, which fortunately has just been a couple times, they've come in and they actually are very professional. They're looking to sit down there and try to resolve that. Most of the time, they would prefer you resolve it to the satisfaction of all parties. They don't want to come in, but when they do, make certain that you pay attention to what's going on and you listen to them and you respond appropriately. But these are the 5 basic things that they're looking for, and they'll be pretty blunt about the whole process. A lot of times on employment privacy, you want to sit down and try to keep these as close as possible. On reporting sexual harassment, the alleged harasser must be told the complainant for the employer to effectively address it. Somebody cannot come up to you and say, psst, 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 this person's being really bad, and they're always picking on me nonstop. If you're going to respond to a complaint on a formal basis, you need to have a formal complaint. If you can sit down and deal with it and observe the behavior yourself, and that person has alerted you, and you go out in the workplace, because sometimes, last time I checked, you're probably a human being. Human beings have flaws, and sometimes we get so engrossed in our duties over here that if something's going on, and unless somebody says, yo, pay attention, you don't pay attention because of the fact, but when they do, even if you have somebody that wants to be anonymous, go pay attention and check things out. See if there's a basis for it. If you see it happening, you can resolve it yourself if you are in charge of employment law enforcement or if you are a position of a supervisor. If somebody has to come up to you and they're afraid of being brutalized by somebody because of the behavior, you need to pay attention to their feelings and their interpretation of what's going on. If you go out and you verify it, you can deal with it yourself. But I've had situations where people go ahead and they want to be anonymous, and that is not what it is the role for you to enforce employment law. If you hear about it, you need to act. That's the rule. You hear about it, you need to act. And the anonymity is very nice, and you can sometimes handle that way, but for the most part, it becomes a formal complaint when they come to somebody in supervision, and because of the fact that they're putting you in a position where they can sit down and file a suit against you personally and against the organization you're part of and saying, I told this person 3 years and 7 months and 5 days ago that this happened, and they failed to act on it. Because sometimes they will keep the date. They will sit down there and sneak a tape recorder in even though it's illegal. They will sit down and take notes in it and be happy to turn around and sue you. So be careful. Make certain you are following the letter of the law. Make certain, if you are not an attorney, that you're paying attention to it. You may want to consult an attorney to make certain you have a good, solid process in place. But the number one process is if somebody reports it, you have an obligation to follow through with it. Sometimes you can sit down and go check things out personally, but the reality is if they want you to formally follow through, they need to formally complain. And the person that they're complaining about has the legal right to know about the complaint and during the investigation. Employers, you need to take immediate and appropriate corrective action. Number 1, stop the harassment. Stop it. Tell them, stop it. Tell them, if you don't stop it, here is the consequences of your action. And sometimes it's the chief executive officer. Usually what happens is the HR person tells them, and then they start looking for another job. Who knows what might happen out of that? It's always pretty tough. And keep in mind also that pretty much at ethics and all things, including sexual harassment, it starts at the top. So make certain that's there. Okay, don't act out of disproportionate situations. Zero tolerance, I'm not certain what that is. Zero tolerance means somebody comes in and they look around and all of a sudden they're guilty. Make certain that you have a reasonable person response in the aspect of what's going on. Pay attention. Is it reasonable to sit down there and censor somebody over here? Okay, so be careful about the aspect of taking every single complaint and believing it and running forward. I've had situations where I have had formal complaints filed and people go out, and here I turn around and they find the person that actually filed the complaint really ended up being the culprit after a lot of research. I've terminated people in the aspect of here's this, you said this, this is not true, this is not true. Please explain this to me, what's going on. When you take corrective action, you need to sit down and make certain you have a reasonable basis to do it. Make certain that the person that's doing it isn't setting up somebody because of the fact that they have a negative evaluation coming or that they've done poor work performance. Sometimes that's the motivation, not sexual harassment. But it doesn't matter what you think it may be. You need to go out and check it out thoroughly to make certain that it is sexual harassment, and if not, take the action there. But if it is, the first step you must do is stop the harassment. Don't act out of disproportionate response. Make certain that it doesn't have the effect of punishing the harassee, like transferring them into the back corner of the warehouse with just makeshift work and then try to find a reason to terminate them. That is not a solution. That is a lawsuit waiting to happen. Damages in jury trials. In some states, a harasser can be personally liable for damages in addition to personal liability and employer liability. The EOC institutionalized an alternative dispute resolution. It just depends what it is, and that could be a matter of a mediation or arbitration rather than courts. Usually the courts try to bump these complaints into mediation or arbitration because of the nature of it, and they consume a huge amount of time. So employees suing for sexual harassment can ask for up to $300,000 in damages. They can request a jury trial. That's all based upon the Civil Rights Act of 1991, which is really an amendment to the original one, Civil Rights Act of 1964. Tort and criminal liability. If you have issues like assault, battery, infliction of emotional duress, false imprisonment, you can't leave there. One time I had a supervisor and she sat there and she was bragging how in a previous situation she had an employee who was doing things, it wasn't sexual harassment, but harassment in a different way. And she stood in the doorway with her hands on both doorposts and she wouldn't let them leave the room. And the person dived underneath her arm and left the room. That is not what a workplace should be like. And if you're doing that, you really need to sit down and see a psychologist for a long-term therapy session. That is not what we're about in the United States. It's called imprisonment, and we don't imprison our employees. We don't put shackles and chains on them. If they want to leave, they can leave. If they want to leave employment, they can do that as well. Potential prosecution for criminal assault, battery, and rape. If you've gone that far, you certainly have your hands full because of the fact that those situations with the crimes like that, it's hard to believe that nobody else in the workplace knew about it before it actually took place. Sometimes it happens, but a lot of times there's a lot of different things happening that people should be talking about it and making certain that you are doing a good job supervising and making certain sexual harassment is not taking place. Consensual activity is not Title VII. If you have an institution of any size, you will have all kinds of things happening because people are people. I've had issues, people complaining about the fact that I had a police officer doing his rounds one night, one of my officers, and he walked into the president's office, and lo and behold, on the president's desk, there were two people highly engaged into consensual activity. I will leave you to figure out what that might have been. I've seen custodial closets, a truly romantic place, having be a rendezvous for two different people. Those are all consensual. They're certainly subject to discipline because of the fact that that is not what you're supposed to be doing at work last time I checked. But the reality is unwelcome sexual advances is sexual harassment. That is different, and it could be between the same gender group, difference in usually gender groups, usually male and female. Okay, the employers, they're responsible. The sexual harassment, severe and pervasive. If that's happening, you will be held accountable to it. Activity need not be sexual in nature to constitute sexual harassment. It could be just based upon the sex of the person. You may have people of the same sex. Whatever is taking place, make certain that unwelcome sexual advances do not belong in the workplace. Sexual advances, having sex in the workplace, is not part of the workplace either. Make certain people are doing their work. If you have a consensual activity going on and it's taking place in the workplace, it makes other people uncomfortable and should not be happening. Flirting is not unwelcome sexual activity unless it's unwelcome. So talking to them is not flirting. Talking to people is not a sexual advance until one of them wants them to stop. But just having a conversation about work is not inappropriate. That is part of work. That's why we call it work. Employers, treat all harassment complaints seriously and act on them quickly. Prevention is imperative to avoid claims and lessen liability, and you need to have a good, solid, written anti-sex harassment policy in place. Policy, procedure, and practice, make certain that you define it clearly, that this is what it is, and it is expected that you not behave this way. Top-down approach is the best way to deter sexual harassment. The overall moral, value, ethical system takes place, and it is top-down. Now, if you have people in the upper tier of your organization that are involved in sexual harassment, you have a problem and you need to deal with that. Once you deal with that, you'll get a whole series of things changing because of the fact you dealt with it at the highest level possible. But a top-down approach makes certain that everybody on your chief executive, chief business, chief human resource, chief marketing, make certain everybody is on board with having a strong sexual harassment program where you're saying, no, it doesn't happen at our place. Remind people of the policy, have training on a regular basis, help them recognize what sexual harassment is, and ensure that when somebody reports sexual harassment, that the activities are taken seriously and the person that reports it is not punished because they did so. Training is a big deal. Make certain you create an environment where everybody knows you're not going to tolerate it, and especially having the people in the very top of the organization endorsing it. Keep an eye out for anti-female animus. Make certain corrective actions can measure it with a policy violation. Keep the workplace friendly, open, and respectful for all. Training is a must. To ignore any kind of complaint is a regret. Retaliation is too common, and top-down determines the ethics of the organization. Take care.